Hello, America. Welcome to a better podcast with business professionals, where we have business professionals, leaders in which field in which they are, come here and educate you about matters of finance, entrepreneurship, and whatever matters to you. So today happens to be our very first launch. Congratulations to us. Thanks for having us. And whatever you need, we got them. If it has to do with entrepreneurship and it has to do with motivation, whatever you need to get more profitable, more successful in your business, in your jobs, in whatever you need, we have them here. Today, as our launch, we have our very first guest. He is an attorney and he'll teach you some stuff you might not have known already, or some misconceptions you might have had. So stay tuned and I'll see you in a bit. Welcome, guys. We are here with Tim. He's an attorney and he's a founder senior partner at a law firm called Cutler Legal LLP. Now, Mr. Tim has over 30 years of experience under his belt. He's been handling a whole lot diverse kind of cases when it comes to the law. And he's guided companies from both startup to the point where they're extremely professional and they're extremely profitable. Now, he's been doing this for, I don't know since when, but he's been doing it through California to Massachusetts. And he's here to teach you about some basic law terms and to advise and also explain some misconceptions that we might have when it comes to law. So without further ado, Mr. Tim.
Hi, Rocky.
Thanks for coming in here.
Oh, Rocky, thank you for having me.
Man, it was all right?
And Trey, thank you for saving me the embarrassment of age. But I have been doing it for about 30 years.
Oh, my goodness.
Yeah.
I wasn't even born then.
Yeah. Most people. But in this profession, experience, I think, helps a great deal.
Exactly.
You don't get distracted by a lot of things.
But
so we don't waste time. What I was going to talk today is about NDAs.
Exactly. NDAs. What was it?
Non-disclosure.
Non-disclosure agreements. A lot of us have been hearing this NDA, but so we get a brief understanding that it's, non-disclosure, something you don't say, right?
Right, and that fundamentally is it, but there's more to it. It's a contract. It's a contract between you and somebody you're showing what you believe to be your confidential information, whether it's an invention, a trade secret, how you do business, customer lists, things that you keep within your company secret that you don't want anyone else to know. But because of a particular relationship you're entering into, you need to share it with somebody else, and you want them to sign an agreement, a contract, not to disclose it. And conversely, you too may be subject to the reverse, where you are being shared information from somebody else and they don't want you to share it. So it's a little more complex than simply a form.
This sounds to be something pretty deep. Now, I've been, I work for somebody and I have my own company too, so I'm kind of a little bit abreast with the term NDAs. But there are a lot of people who sign NDAs but don't understand it, right?
Yep.
They go to jobs and the jobs have them sign NDAs. It's a contract, like you said.
Well, and that's a misconception. You don't sign them when you go to a job. You might sign a confidentiality agreement, which is very much similar, but you go to your employer and the employer says, okay, I want you to sign a confidential agreement. You won't share any of our confidential information. And that is very similar to an NDA. But an NDA is more in a situation where you go to a venture capitalist and you're trying to raise some money for your invention or your new idea. And you don't want to go in there and share that with the venture capitalist and have them then give it to somebody else. Or perhaps you're selling your business and you have a prospective buyer comes by. And that buyer wants to know your books, know who your customers are, know who your operations, and in order for them to consider whether to buy it or not. But at the same time, you don't want to share all that information because let's say they don't buy the business, and then they take that information and they use it. So you want to put them under a contract that says, no, you can't.
Okay, so you're saving yourself from them putting you out there, putting your information out there.
Exactly.
For people to know. Makes a lot of sense now. So, what basically makes an NDA an NDA? What's included in it?
Oh, that's a great question. You want a description of what your confidential information is. Obviously, you don't want to describe the confidential information, but the general category is broad. Customers.
Something like a broad, explanation or broad.
Inventions, or anything I designate as confidential. You also want some language that says that both parties agree that if someone takes this confidential information, you're entitled to equitable relief. Meaning you could go to court and ask the court to issue an order to stop the other party from using that information or distributing it. And you like that agreement up in advance before you go to court. So when you go to court, you go, hey, judge.
We gave them this, and they didn't go by it.
Right, and they agreed that if they did that you could issue an injunction. So it takes out that step. Another thing is, please make sure that the law that applies and the jurisdiction which you enforce it is in your state, not in the other person's state, because that's an immediate invalidate, or that immediately makes it impossible to enforce your NDA, or almost impossible. Because now, let's say for some reason you live in Connecticut, and they say, well, let's make the law Chicago and the enforcement area is Chicago. That means you've got to go to Chicago to enforce
every time to enforce it.
You're not going to do it. You don't have the money. You can't do it. So that's a trick way of doing it.
So when you want to enforce NDAs, it's best that you do it in your local state.
Right, because of economics. You're there. You don't have to fly to another state. And it's easier to get a lawyer in your own state.
Awesome. Man, that's some huge information, some huge nuggets right there. And when are NDAs used? When can they be used?
They can be used. And I'm sorry, let me go back one other thing. The other thing is put in an attorney's fees provision, because that's going to be your biggest club. If the person goes and violates the NDA and you can recover your attorney's fees, one, obviously that's a great relief to you because in the end you get your money back from your attorneys, and that's an added cost to the other side. So that's a big one. And I apologize.
No, it's okay. I actually needed to hear that. So when you have someone that's violated their NDAs and you take them to court, now they can pay for your attorney fees.
You can, if you have the clause, but unfortunately, it's only at the end of the suit. So you have to go through the suit.
So you're going to go through the cost.
Yeah, you pay out the cost, and then if you're successful, the judge then can turn around and award you your fees.
Exactly.
The courts don't automatically. You have to, in order to recover attorney's fees, they have to be in the contract.
Okay.
All right.
Awesome. So let's go back to the question: when an NDA is used?
NDA is used if I'm raising money, I'm selling my business. Let's say I'm starting up a business. Let's say Rocky and I get together, and you say, "Hey Tim, I got this great idea, and I'd like you to maybe come in as a partner." But I want you to sign the NDA first, because I don't want you to take my idea and go off and get somebody else
for it.
Right. So anytime you're going to share your personal confidential information or the confidential information of the business, again, whether it's customers, an idea, a business plan, marketing plans, or obviously an invention, those are the times when you want an NDA. Now, there is some language, too, that you want to avoid in your NDA. Sometimes, and that's the trick of contracts. There's things you want in contracts, and there are things you don't want in contracts. And one of the big things in an NDA you don't want is an arbitration provision.
And what is that?
That says that you don't have to go to court, and you can go to a third-party arbitrator and have them decide it. And many people on the surface think, oh, that's great, it's cheap, it's fast. But no, it carries a lot of pitfalls that, particularly in this situation, are very problematic. First, an arbitrator cannot order a party to do something. You cannot order them to stop using your trade secret. Because if you tell the arbitrator orders that, and you go to the arbitrator, well, forget it, I'll still do it. The arbitrator has no force, nothing to enforce it.
Okay.
Or a judge can put you in jail. That's a big incentive. Two, arbitrators tend to go with whoever will give them the work the next time. So
they're looking at their client base.
They're looking at their client base, and they tend to make their decision on where can I get the next appointment, not what the law.
Not to actually benefit you, but for something that's going to benefit them.
Exactly.
I see.
So people will, try to push an arbitration clause and say, "Oh, there's standard language. Don't worry about it. That's what you should have in." No, you should worry and you should say no. The other thing is any language that would delay the enforcement. Another thing someone might want to put and go, okay, well, if I'm violating it, we should talk first. We should have mediation. We should get together. Rocky, we should have a conversation.
Mm-hmm.
And if we can't work it out, then we'll go to the next stage. No, because that's just going to be a delaying tactic. And during that period of time that you're supposedly talking and resolving this dispute, they're out using your confidential information and selling it. You want to act quickly and immediate, and you don't want anything delayed. That includes mediation. You don't want to build in mediation. Mediation is bringing a third party in and trying to resolve your dispute.
So, when would I not want to use an NDA?
If you're an a venture capitalist, they traditionally do not sign NDAs, and their big concern is if someone comes in and presents an idea to them, and they say, "Well, maybe you're not a good business person," or something about that aspect of the idea we don't want to go with. Then someone else comes in with a very similar idea, and they like that, and they like who's behind it, and they want to go with that. They don't want the first person to come back and sue them, claiming, "Oh, you stole our idea," with regards to the second person. So venture capitalists tend to find that NDAs are unnecessarily restrictive, and they don't sign them. And anyone in the position of lending large sums of money into different businesses tends not to want to sign them because they don't want someone to come back and say that the business they invested in, they stole from another business that had come before and shown them the idea.
Okay. All right. So this makes a lot of sense. So would I need a lawyer to draft out an NDA?
Yes. I'd recommend a lawyer to look at, because you can go online, you can pull off an NDA, and it may serve you fine. But an ounce of prevention is worth a pound of result.
True.
And so often people sign things, they draft things that have huge holes in them. I have many times clients bring contracts by that they ask me to enforce, and I have a great difficulty enforcing them because there are fundamental mistakes and holes.
They're fundamentally flawed.
And they just, as a lawyer, we just get trained to see how to fill in all those holes and avoid problems. And if you're signing an NDA, it's always good to have a lawyer look it over. It's not much money to see if there's an unnecessary restriction in them.
Okay. So actually, it's recommended to have a lawyer look at an NDA before you actually, accept it. And that doesn't mean that nobody can do it. Actually, everybody could do an NDA or come up with an NDA, correct?
Absolutely.
Okay.
Like any contract, anyone can write a contract. It doesn't require a lawyer to write a contract to be enforceable. But the issue is when it comes time to enforcing, what made all the sense to you when you wrote it makes no sense to a third party.
You better be safe than sorry.
Correct.
Better yet. So, guys, you could actually fix your own car, right? You could change your own oil, but you might as well take it to a mechanic to have it done right? You don't want to, cascade a whole lot of problems coming up. See, in that same sense, if you're drafting out an NDA, I'd suggest you have a lawyer take a look at it. Have an attorney look at it. Try to fill up the holes that you might have in your NDAs. So, is there any languages that I should avoid when I am signing an NDA or I'm having someone sign an NDA?
Absolutely. As we talked about the arbitration language, we want to avoid having it litigated in someone else's state. Also, a non-compete. You don't want any form of non-compete in there or unnecessary restrictions on your rights to do anything other than disclose the confidential information. Once you start giving up other rights, you don't want that. 2, you don't want anything that would delay the enforcement. You don't want to be required to have negotiations or mediation that would delay the enforcement.
All right. And all of these seem pretty tricky. Why would I want to use an NDA if it's this tricky?
You want to use an NDA for a variety of reasons. The first one is the old adage is to keep honest people honest. People who sign a contract tend to feel obligated to abide by it. Now, it doesn't mean they will, but at least there's a moral encouragement there. Two, if they do take your confidential information, then you have a leg to stand on to go to court. Then you have something to bring to court and say, hey, they knew that this was confidential and they knew not to take it, and that's very powerful. Three, it helps give credibility to your company. And finally, you need to set up a process to protect your trade secrets. Down the line, your company may be getting bigger, and then someone steals your trade secret, and the issue is going to become, is it a trade secret? And in order to determine whether it's a trade secret, you must show that you took steps to protect it. And having NDAs in place are an indicator that you have taken steps to protect your trade secrets.
Awesome. Hey, we're trying to keep honest people honest. People who are not honest, well, be careful. It's going to be coming for you. All right, so I believe we've actually answered a whole lot of questions, a whole lot of misconceptions that people had when it came to NDA. And on that note, I'm going to be closing this session. Tim, thank you for coming through.
Okay, thank you.
Oh man, I'm blessed for you having to have you here. So guys, without further ado, I'm going to call it a close. Thank you for hopping out this time. Thanks for being an audience. Thanks for being a viewer. And I'll see you on the next episode. See ya.